Twitter.
Good evening. Over the last few weeks, it's become apparent that new legislation has come into effect compelling trade unions to hold a secret ballot of workers in their particular workplace before they go on strike. In other words, if workers at a factory want to go on strike, they have to canvass all workers in secret before a work stoppage is allowed. If they don't do that, the Labour Court could rule that the strike is not protected. This measure came into force after what looks like an agreement with business, in which business agreed to a national minimum wage for the first time in South African history. But the trade union NEASA is now going to the Constitutional Court to challenge the strike ballot provision, saying it is unconstitutional. NEASA is an affiliate of the South African Federation of Trade Unions. Their General Secretary, Zwelinzima Vavi, joins us tonight to discuss this. Also in the studio, Gerhard Papenfus, the CEO of the National Employers Association of South Africa, who I think believe that a secret ballot before a strike is necessary. Gentlemen, good evening. Thank you so much for coming in.
Oh, Stephen.
Ms. Vavi, I'm going to start with you first. Why, under this new law, workers would be asked, basically, whether they want to go on strike or not? What's wrong with that?
Look, for all these years, workers have chosen to exercise their right to ballot each other as part of their mobilization efforts, and or to decide that what they hear from the members is suffice, and they will then go on strike on that basis. We find it very strange. In fact, we're not finding it strange. We know what this thing is about, that this is a full-blown attack on the right to strike. This is yet another attempt by the employers of South Africa who have captured the state to do bidding for them, and in order to make sure that workers find it absolutely almost impossible to exercise their constitutionally guaranteed right to strike by introducing this amendment to the Constitution. And we rejected it for two reasons. Firstly, we absolutely livid that the employers are now wanting to instruct the unions, which are a closed association of members who belong to that unions, that they must amend their constitution, and this is how they must exercise their democracy. This has absolutely nothing to do with the employers. The employers must mind their own business, and the captured state must stop being a small braggy who act on behalf of the bosses of this country, so that the right of workers to exercise their hard-earned right to strike is frustrated. The second reason why we reject this is that it is introducing an administrative nightmare. No union, in fact, not even the Independent Electoral Commission, the IEC, that conducts elections every 5 years in South Africa, will have the capacity that is now required that the trade union movement should have, i.e., to ballot workers in each and every workplace every time they will want to exercise their right to strike. This is meant to emasculate the workers. This is meant to end collective bargaining and to introduce collective begging. This is about tying the hands of workers from behind, and then tell them to go in and negotiate with the ever-increasing power of the capitalist class in our society.
Okay, surely the people who support this would come back at you immediately and say, firstly, it's become very easy and quick to have some sort of app or some kind of SMS system. Someone will provide a cheap service to do this eventually. It won't take long. Someone will spot a gap. Some capitalist will spot a gap in the market. Let me just finish the main point, though. But the main point surely is that if union members do not agree to go on strike, there shouldn't be a strike. And what more democratic way than a secret ballot?
Absolutely. But remember, Stephen, the Constitution provides a full right to unions or even the employers, that they have a right to an administrative independence, to manage their affairs, to conduct their own business in a manner that they see fit and in line with their own democratic processes as prescribed by their constitution. It is absolutely wrong for the employers to now want to insist on the trade unions as to how they must exercise their right. It's not their business. It is the business of the members of the close association, and that's what the Constitution guarantees us. And that's why NUMSA, with our full support, and I guess the full support of the overwhelming majority of workers, is going to the Constitutional Court to say this is an attack not only on the right to strike, but this is an attack on the constitutional guaranteed right to administrative independence of the trade union movement.
Gerhard Papenfus, why suddenly are employers so worried about democracy and unions? Surely it's none of your business.
Yeah, you know, both Mr. Vavi and I was not at NETLAC when that was negotiated for very similar reasons. You know, the route to NETLAC is controlled by self-appointed people. But there's a bit of a misconception here. What the new legislation says is that a union must have a provision for a secret ballot in its constitution. And it stops there. It says nothing more. And the explanatory note says that if you don't have that secret ballot, it have no impact. We as employers can't go to the court and say to the court that since you haven't had your secret ballot, you cannot strike. The court won't listen to us because that's why I have these notes here.
That's interesting because I spoke to a Labour lawyer on the SABC yesterday morning, Puko Maso Remule, and he was very clear. He said a Labour court would rule that it was unprotected if you didn't have the secret ballot first.
No, it is. Sorry, if you don't mind, if I read it here, the code of good practice. On collective bargaining, etc. The Act does not, it says, the Act does not require the conduct of a ballot as a requirement for a protected strike of lockdown. There it says.
Okay, that's not how you see it, Mr.
But here's the point. The obligation to ballot flows instead from the constitution of the registered union. Registered trade unions and employees organizations that are obliged to comply with their constitutions, even though the failure to do so does not have the consequence of invalidating the protected status of the strike or lockout. So what was negotiated at NETLAC was actually, from an employer's point of view, meaningless. It was poorly done, but this is what it is. So that doesn't help employers at all. And but what it is aimed at, and I think what concerns the trade unions, is that since that is in their constitution, you know, I've been saying for a very long time that the violence in strikes is as a result of the lack of support by the unions. They have to force members to participate in strikes. And union members or workers, not union members, workers that don't, we know, you know, there are deaths in these strikes. People die. They lost their livelihood in these strikes. The levels of intimidation is extremely high to take them out in order for them to participate in the strike. And that the violence, that is my point of view, is the only weapon that was left. This, to some extent, is a bit of a problem for the unions, because any trade union member can stand up and a union member can go to a court and say, this strike wasn't secretly balloted properly. I'm forced to participate. I'm intimidated to participate. I don't want to participate, but the employers can't do it. And here's the documentation for that. So I hear what's being said. Now, what's been happening there is there has been a particular employer that went to the court to block a strike. But what happened there, the court said to this union, since you don't have this provision in your constitution, I can't help you. So the strike is unprotected. The moment so it's actually meaningless. The moment...
How could that be meaningless?
The moment
because that's exactly the point that...
No, I say from the employer's point of view, it's meaningless. The moment that provision is in the constitution, even if the union does not comply, it is not for the employer to challenge it. It can be another union member to do that. So the employers do not have actually protection here, but workers do have protection in this
All right,
thing.
Mr. Vavi, you've been shaking your head at a lot of what Mr. Papenfus has said. So
I didn't see him shaking his head.
Because the notes that he has are wrong and they are not the law.
the law is that
The
you have
law,
to have a ballot first.
What he is mistaking and what the many employers, and including the people who negotiated this piece of law, had not done is to do a proper work. They didn't scrap a section 67 of the LRA, subsection 7. That was based on the arrangement from the time the LRA came to an effect in 1995, 1996, where it said, even if in your constitution there is a provision that workers will be balloted, the strike will not be stopped on the basis of you not exercising what is in your constitution. So there's always a requirement that unions must have a ballot in their constitution. We accepted that because even if you didn't exercise that, your strike will still not be ruled as an unprotected because you have not exercised what is in your constitution. They have now amended the law. They are now expressly saying in section 59, in the terms of the new amended LRA, that the trade union movement must firstly amend their constitution, which is the point that you are making, you're conceding. And when they've amended the constitution, the trade union must ballot their members secretly. And if they don't, they run a risk of having their strike unprotected. Secondly, they run the risk of their unions being deregistered. And thirdly, they run a risk of having their unions put under administration. Now, there can be no bigger attack on the independence of the trade union than some fellow sitting in some nice office, as the registrar have done in issuing these regulations last week, to say from now on, guys, I want to rule over you and I'm going to ask you to convene your congresses, all of you, amend your constitution. The registrar and the employers have absolutely no business in telling members of the closed association to convene congresses. Who's going to pay for these congresses and then to amend their constitution? That's not their business.
I'm sure the Labour Registrar will come straight back and talk to several situations where money has been abused by union leaders. We'll come to that. Neither of us are lawyers, so maybe we'll step away from the law a little bit. Zwelinzima Vavi is the General Secretary of the South African Federation of Trade Unions. Gerhard Papenfus is the CEO of the National Employers Association. We'll continue our conversation tonight around secret ballots before strike. Stay with us. All right, welcome back. On the Record continues. We're continuing our conversation around the new provisions in the labour law which appear to require the secret ballot of workers in the workplace before a strike can be called. Zwelinzima Vavi is the General Secretary of the Trade Union Affiliation of Federation SAFTU, and of course Gerhard Papenfus is the CEO of the National Employers Association. Now, I want to step away from the letter of the law. I'm not a lawyer. I don't know if you are. I think, Mr. Vavi, that you're not a lawyer as well. But I want to focus on the principle. Again, why is it the business of the employers how a union decides when it's going to go on strike?
Before I answer that, I just want to say that I think I'm disappointed in this, that the employers do not have so much power in this thing to utilize the absence of a strict application of the law to stop a strike in the court.
I realize your disappointment. Please answer my question. Why is it your business?
If a strike is conducted for the purposes of withholding labor, we understand that's the power that workers have. What is happening in our labor dispensation is that workers are forced to participate. There's no freedom of this. There's no democracy in this dispensation. Workers are dragged out of the workplaces. If you don't participate, your house is burned down. And this is a general statement. It doesn't happen every time. Your house is burned down. Your life is threatened. strikes have become extremely violent. It's a battleground. If you will come with me and I show you that employers have to set up war rooms to see what's going on, to protect properties, to see where strikers are going to, and people's lives is at stake here. So what we say is it should have been made our business even more. The state has intervened here belatedly and a bit reluctantly and a bit hesitantly, but at least there's something now. So we want to stop. We want a democratic thing that if all the workers say we want to go out, well, then it's so. We say, and that is our view, the majority of workers is not in favor. And if you have a secret ballot, you might just find that strikes won't go ahead.
Okay, 2 points. Firstly, isn't there already a democratic safeguard because union leaders are elected, right? You can't have a strike without workers supporting it. It doesn't make sense. Workers have to support it.
I don't think so. I think, you know, to stand up in the dynamics of a trade union meeting in a hall where people is heated up and say we're going to strike, for a worker to stand up at the back of the wall and to shout, no, we're not going to do that, we mustn't do it. It's just not happening. The dynamics of the moment dictates that it's not going to happen, and that's why the secret ballot. This is the safeguard that's being built in.
Okay, and the second point is, we have time and time again, the Labour Court will rule that a strike is unprotected, right?
Yeah.
It doesn't stop the strike. It doesn't do anything. So isn't this yet another piece of legislation that is not enforced and doesn't actually change the nature of our strikes at all?
You know, if a strike is unprotected, and we're not going to go into the legalities on what the impact of this is, but if a strike is unprotected, of course you can sue for damages. And employers are reluctant to do it. You know, once the strike is over, people say, let's go to work and let's go on with our lives. But I think that must stop now. I think employers must really go to court and sue.
Okay, but you didn't answer my question. I mean, introducing a strike ballot isn't going to stop strikes. Because even if they don't do it and the strike's unprotected and the Labour Court rules it's unprotected, it doesn't matter.
But that brings me back to my point in the first place, that I think there's shortcomings in this legislation. I would have liked the thing to be much more strict, to give the employer the power to say, we insist to see what's happened in that strike, is a ballot, is it properly done, so that we can go to court. I don't think we have that power. And it will be left to the union to do it the way they want to, even if they will do it at all. And there's not much we can do about it, and I think that's a shortcoming in the Act.
No. Mr. Vavi, isn't it true that there have been instances where some union leaders, particularly when it comes to money, have abused the financial power that they have over a union? There are various examples we could go into. Some of them have come very close to being deregistered as a result, but in some cases, millions of rand have gone missing. This suggests that we can't trust every union leader, even if they are elected. So back to my original point, doesn't having a strike ballot then make sure that the union leaders, it keeps them more honest?
There's a separate regime as to what the department must do every time the trade union movement leaders steal from the workers and betray their trust. The issue of the strike and the secret ballot is an absolutely separate matter to that. The workers themselves must at all times make sure that they develop their own confidence, politically and organizationally, to tackle the leaders who abuse their power in that fashion. So we shouldn't mix that. The second part, as we speak, 2 strikes have been interdicted. Not in future, now. Workers in Fosco have been stopped from going on a strike because the judge says NUMSA's constitution doesn't have a provision for a secret ballot. In another company, same judgment, and that's why NUMSA is appealing. And we hope that it is going to take that into the Constitutional Court. So the third issue that I think that Gerhard is missing, even if there was a 50% plus 1 of workers voting in support of a strike, there will be some others who do not want to go on a strike. There is absolutely nothing in the legislation that can stop intimidation. Intimidation gets stopped by the police action. It is wrong, and we don't encourage it. We always condemn it every time it happens. But that's a function of the state to protect the right of workers who do not wish to participate in a protected strike or even in an unprotected strike. The legislation is not going to help that in any way. So I feel that I must emphasize that. So we mustn't cloud issues in order to justify a salvage attack on the rights of workers in this country, an attempt by a bourgeoisie state, a capitalist state, which have been employed and captured by the capitalist class to tie workers into an arrangement where their last weapon will be taken away through a bureaucratic maneuver, as it has happened through the amendment of this legislation. Right. Now, Gerhard says he wished that he could have more, so that I'm sure he will want to sit in the meetings and hire agent provocateurs to go to court and sponsor them to go and challenge whether the secret ballot was conducted fairly and whether there were technical problems here and there, which is our nightmare and our biggest fear going forward, is that they will find people to sponsor, to go to court. In fact, in terms of the law, contrary to what they are saying, they will be allowed to challenge the results of the secret ballot on the basis of allegations that could be manufactured. 10 people can come forward, will give you 7,000 rands more, make up an affidavit that I was intimidated to vote yes in that secret ballot. So the system is open to an abuse because the government is trying to interfere with the internal arrangement of an organization that have been formed by other people that are independent from the government. This is an attack on the freedom of association. That's why we are not only aiming to take it to the Constitutional Court, but we will take it to the ILO and say this government is undermining its own signature in terms of the Convention 87 that talks to the issue of freedom of association. But more importantly, Stephen, we are not going to turn into the other side and get more clapped. We are going to the streets and we are calling on our members to prepare for a total occupation of South Africa in all of the cities until this government agrees to withdraw all of this insult and assault on the right of workers to strike.
Okay, I mean, I'm going to come back to that in a moment, but I do want to just ask you, Gerhard, I mean, in a situation like this, are you going to be a party in the court case? Or are you going to argue in the Constitutional Court?
I think that this piece of legislation is so meaningless that we won't, because it doesn't give employers enough. We're actually not a role player in this thing. You know, Mr. Vavi and I are looking at the same thing from a different angle. The influence that capital has on government, from my point of view, is so limited. You know, that's our frustration. We beg to be heard. Our view is that the appropriate ministers really listen to them, but not to us. But we're looking to the Table Mountain from two sides.
They used to. It gets a bit complicated.
Yeah. But yes, the thing is exactly the two. He says that in two cases the Labour Court interdicted the strike. That might be so. I'm only aware of one, but what happened in that one case is exactly that. The court said, since you don't have that in your constitution, I cannot protect you. We say if NEASA had it in its constitution, they would have had the protection that the court would have granted them. So this thing doesn't help us. And I think, what I agree with Mr. Vavi, I understand that to comply with all the technicalities of the ballot might be a nightmare, but it's not for us, the employers, to even utilize the court to say there were shortcomings. We're out of the game. It might be somebody amongst their own ranks that might do that, but not us. So I think there are severe shortcomings. I think this is a lame piece of legislation that means nothing to us. Scare them a bit, and we sit here, look at it, and we say, we don't know what you're scared of. Maybe perhaps concerned about your own membership. But if this is a piece of legislation, if they go to court, we'll sit back and say, what must happen, must happen.
I didn't expect you both to be opposed to the legislation. Right. Gentlemen, thank you very much indeed. Zwelinzima Vavi, the General Secretary of the South African Federation of Trade Unions, and Gerhard Papenfus, the CEO of the National Employers Association of South Africa. That's on the record.